Call the first case on this morning's docket, case number 112069, State of Kansas v. Keith Ritz.
May it please the Court, Heather Cessna with the Appellate Defender Office here on behalf of the defendant, Mr. Keith Ritz, and I would like to request 4 minutes for rebuttal time, please, Your Honor.
4 minutes is granted.
Thank you. I would like to start off this morning with issue number 2, which is the lesser included offense issue, and specifically I'd like to start off talking about the Kansas constitutional argument that we've made in our brief. Obviously, this court is the ultimate decision as to whether or not there is a Kansas constitutional right to lesser included offenses. Our argument is that there is, and that therefore the statutes that eliminate lesser included offenses for felony murder is therefore unconstitutional and would require reversal in this case. This court has previously held that the Section 5 specifically of the Kansas Constitution that talks about the right of trial by jury shall be inviolate preserves the jury trial right as it stood at the time of the common law. The common law at the time of the institution of the Kansas Constitution allowed for lesser included offenses for all crimes, and it's our contention that as a result, Section 5 preserves that right in the common law.
Let me stop you there. What is the source of saying that it's a lesser included offense for all crimes as opposed to a lesser included offense as the legislature might define the term lesser included offense?
I think it's based on the idea that at the time of the institution of the Constitution, it did include all of the crimes. There wasn't a distinction made. Certainly, this court has held in Miller v. Johnson that the legislature can amend essentially some of the common law concepts, and we talked about that a little bit in our brief as well, that under the test that the state would have to prove that they've created a alternative essentially there, and that it's there to serve a specific right if they're going to take that right away in order to comply with due process arguments. So I mean, I think there's the possibility of amendment. Now, our first argument is essentially that because of the plain wording of the Constitution and the specific rules that apply to defendants as opposed to civil litigants, that the question of whether or not there is a constitutional right should end at the point at which we determine that there was a right at the time of the institution of the Kansas Constitution, and therefore any violation of that is a problem. And so our first line of defense, Your Honor, is that at the time there was no distinction, and because criminal defendants have a higher protection than civil litigants, that's sort of the end of the conversation, and therefore any attempt by the legislature to amend that would be problematic in a criminal case. Now,
So Ms. Cessna, were we wrong in Carr and Gleason and Salary when we said there was no constitutional dimension to lesser includeds?
well, Your Honor, I think the short answer to that is I would say, particularly under the Kansas Constitution, yes, although the Carr and Gleason are not specific to the Carr and Gleason arguments. I believe were based on a distinction between back in the federal constitutional law, and in that case, the problem there was that the elimination of the lesser included offense for capital murder was not all of the lesser included offenses. It was just the lesser included offense of felony murder. That's how this court distinguished those cases from.
I think that's what Gleason was about, but I think Carr went beyond that and talked about the elimination of lesser includeds for felony murder as well.
Yeah, I mean, I think that under that case law, then yes, that the interpretation of the Kansas Constitution would be wrong. And I have to admit, I did not pull the briefs in Carr to see exactly how that constitutional argument was made, but our argument would be that under the Kansas Constitution, that it's not the same as the federal analysis because there is the specific right in the Kansas Constitution that doesn't occur in the federal Constitution, saying that the right to jury trial is inviolate.
Even and I think under your argument, does it matter that felony murder is not a common law crime?
Your Honor, I would say that In this particular situation, it doesn't, because I think the common law required lesser included for whatever crime you were charged with. So I would say that that might be a distinction, but I would argue that it's a distinction without a difference, because the question that we're talking about is the jury's right to consider lesser included offenses of whatever crime there is charged with. So I would couch that as it's the jury's right to not be presented with this draconian false question between an all or nothing culpability determination. And so in that context, I would say that even if even with felony murder not potentially being a common law crime, that the question that we're talking about here, which is the jury's right to lesser included offenses, is part of the common law.
Is it the jury's right we're talking about, or the defendant's right? You're talking about the defendant's right to have the jury consider something other than all or nothing, aren't you?
Right. I mean, it's kind of a circular argument in the sense that it's the defendant's right to have the jury make that decision, but it's the jury's right to be able to choose those levels of culpability. So I think it's a combination of both, Your Honor.
But you've lost me there when you say it doesn't make any difference that felony murder was not a common law crime. How then were lesser included offenses determined in 1859? You understand what I'm saying? Is you say that at that point all crimes were entitled to have lesser included offense instructions, but to get there you have to define what is the lesser included offenses, and if the crime didn't exist, who defines what the lesser included offenses would have been if the crime had existed in 1859?
I think my answer to that question, Your Honor, is that you're defining them based on what the crime is now, as far as whether or not they're factually appropriate. I think the idea that lesser included offenses were allowable under the common law is the general concept that we're relying on from the common law. So at this point, we're looking at it from the perspective of what is it that under this particular fact scenario is going to factually support a lesser for felony murder, and the question is whether or not lessers of whatever crime were charged. And that's, I mean, I think one of the things that we have to keep in mind is that at the time, the common law didn't make a distinction between what crimes allowed lessers and what crimes did not. It was just a blanket, whatever crimes there were allowed for lessers. And so our argument would be that at this point, with felony murder being a statutorily defined crime, this question of whether or not the jury has the common law at the time, constitutional right under the Kansas Constitution to consider the lessers, is what we're applying to the current crime of Mr. Ritz's conviction.
So we look to the law at the time the Constitution was ratified
To determine
just to determine your rule about lesser included, but
Right.
not to determine the definitions of any common law crimes or what their lesser includeds might be. You want to. This is why I'm struggling. You're pawing back into history for a very general proposition that suits you, and wanting to ignore it for the more specific propositions that may not help.
And the reason why we're relying on the reason why we're talking about it in those terms, Your Honor, is because the particular statute that we're calling into question right now is the one that says that there are, under the felony murder, there is no lesser included offenses allowable. And so the question is whether or not there's a constitutional right to those two lesser included offenses on any crime, basically. And the statute or the common law that covered that, I don't think was specific to a particular crime. And so that's why we would argue that the constitutional right that is preserved under the Section 5 of the Kansas Constitution would preserve that right that then can be applied now to the question of whether or not, for instance, under felony murder or under capital murder or under any of those specifics, that whether or not there is a constitutional right to the lesser included. So I understand your concern, but I think because we're talking in terms specifically of something that at the time of the Kansas Constitution was a general right to whatever crime existed, that it's not a question of whether or not the felony murder or existed at the time or whether or not there was a specific provision that allowed lesser includeds for felony murder. It's that the right to lesser includeds wasn't specific at the time. It was applied to whatever the law was at the time. And so I think now then looking back on it, we can talk about whether or not that's a general right that is allowed. As I said, our argument under the Kansas Constitution is that because the right is inviolate, that should end the question. That under the facts of this court previously considered in State v. Berry the exact same fact situation of a flight that required a high rate of speed and reckless driving through residential neighborhoods that ended in an accident that resulted in a death. The court determined in Berry that those were sufficient facts to justify the giving of the lessers that we requested in this case. And the state has made no argument other than to accuse us of abandoning the issue. They've made no argument that those factually would not be supported under the facts of this case. And we would argue that in the brief, although certainly I could have put more words in there in order to make the point is pretty simplistic, which is that these are the same facts that this court determined under Berry supported the factual giving of the lessers.
Before you run out of time, could you address your joinder argument? I'm having difficulty understanding how these two separate acts that occurred about 3 months apart aren't of same or similar character. In fact, it's eerily similar and eerily of the same character. It's the only difference appears to me to be perhaps a different vehicle, and that the last one resulted in a death.
And
what's the difference here?
Well, and I would caution you to not take those differences too lightly. I think that those are significant differences. Not
What, the fact that one was a truck and one was a Corvette, that's not
not necessarily the specific car, but the fact that one did result in the death whereas the other did not. I think that has the potential to cause some real prejudice from one case to the other. The argument that was made below was that, and that we made on appeal, was that the severance was necessary because there were also different defenses, essentially, more or less, to the two crimes. I think in one case he admitted that he had actually stolen the Corvette, which went to some of the other crimes of conviction here with the theft. And then in the second case, he argued that essentially he didn't know that it was for sure a stolen vehicle that he was driving at the time. Or that was the statement that he had made to police, at least.
You made a statement, but yeah, okay.
And so I think the combination of those differences and the addition of the actual death that resulted in the second case was the basis for arguing that although they involved the similar crimes and a similar fact scenario, that they were not similar enough, and they were, because the second one involved the death, that they were particularly prejudicial under the analysis. With that, I see that I have run out of time. We'd submit the rest of our arguments on the brief and ask that based on the arguments that we've made here today and the arguments in the brief, that the court vacate the convictions or remand for a new trial.
Any more questions of counsel? Thank you, counsel.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'll just begin with issue one. I agree with Your Honor that this is a case that is so similar in nature that, as Judge Kaufman put it correctly at the time of the pretrial motion on this issue, if this case is not appropriate for joinder, then joinder might as well just be done away with as a concept. What the defendant has been able to do in his brief, and again at the oral argument, is point to certain facts that make these cases not identical. What he can't do is point to any case law or statutory authority requiring the two cases be perfectly identical in order for joinder to be appropriate. Of course, that's not the test. The test is whether they're substantially similar, whether they're of the same general character. And in this situation, the two incidents were so similar in nature, beginning with the fact that on both occasions he was driving a stolen vehicle. On both occasions, he waited to flee until the officer had exited a patrol vehicle and started approaching his car on foot. Both times, he did not have a valid driver's license, which would show a motive to flee, in addition to the fact that the cars were stolen. Both chases, he drove at very dangerous speeds on city streets, including residential roads on both occasions. He ran multiple stop signs during each of these pursuits, and neither pursuit ended voluntarily. Both pursuits ended with the defendant violently wrecking the car. Fortunately, the first occasion, he wrecked it into an object, a light pole, as opposed to another vehicle. But given all these similarities, these are textbook examples of charges that should properly be joined. And as I pointed out in the brief, the case law is such that only in extremely rare circumstances will joinder ever be found to be an abuse of discretion. My research indicates that there have been perhaps 2 published cases over the last several decades where reversal has been the result. This case certainly should not be the third. Turning to issue 2, the lesser included issue, the defendant has raised it as both a federal and state constitutional issue. I've cited in my brief numerous recent opinions from this court that I think combined indicate that the defendant's argument should not succeed. Todd, Gleason, and Carr, of course, are 3 of those opinions. And I'd also point to State versus Salary, where this court specifically found in a harmless error analysis that the right to the lesser included offense is simply a statutory right, and therefore the statutory harmless error test should apply rather than constitutional. Taking these cases together, I think that those 4 cases defeat the defendant's argument. I agree with some of the points that the court was making in questioning counsel today. You have to look somewhere to determine what is or is not a lesser. The legislature has determined that there are no lessers of felony murder, and there does not appear to be any constitutional problem with that. As your honors pointed out, I think that the defendant is wanting to have it both ways, essentially, and looking back to the common law for certain things, but not others. As your honors pointed out, there was no felony murder at the time. It was not a common law crime. And so the defendant is trying to ask you to look to common law for certain parts of her argument, but to ignore it with respect to others.
And more to the point now, there are no common law crimes.
Exactly. And so, again, we have to look to the legislature to determine what is a lesser offense, and the legislature has determined that there are no lesser offenses of felony murder. Again, this is not something that this court has not considered in various forms in the very recent past, and the state's position is simply that this court should adhere to those rulings and should find that there is no constitutional problem here.
Those rulings, counsel, I'm sure you'll agree with me, have been in a much more general way. I think Carr and Gleason in particular were due process rulings. This is more where I see the defense putting most of its emphasis today is on the inviolate right to jury trial under Kansas Constitution. Do you disagree with the basic proposition that at the time of the Constitution's adoption there was a right on the part of a criminal defendant to lesser included consideration by a jury on all crimes? Do you just agree to that basic general proposition on which she's placing so much reliance?
I think I would agree to that. To that basic proposition.
You're just saying we don't go there anymore because now we have statutory crimes only, and lessers are defined by statute. End of story. Exactly.
Okay. All right.
So
for those reasons, the state by no means agrees that there is either a state or federal constitutional problem here, and for that reason, I would obviously argue that there's no reason to look at the facts of this particular case. Just to cover all my bases here, I would argue that factually the defendant's brief is lacking as far as support for why it would have been appropriate in this case. I believe it's on page 22 of the defendant's brief where there's essentially one sentence just saying this case is similar to Berry. There's no cite to any facts in the record in this particular case. So I would argue that that is essentially abandoning that argument without providing any specific citations to the facts of this case. I'd further note, as I did in the brief, that the underlying crime that the defendant was charged with in this case is not even the same underlying felony that was at issue in Berry. So for those reasons, we would assert, as we did in the brief, that this was not sufficiently brief from a factual standpoint. I believe I've covered all the points that I intended to. Again, it's our position that there is no relief on this constitutional argument, be it state or federal.
If you agree that all crimes had lesser included at the time of Constitution, and do you agree that that implicates Section 5, the jury trial right?
Yes, I would agree with that.
Well, then what's the adequate substitute remedy? If we're going to take away that right, don't we have to provide an adequate substitute remedy for that? You know what Miller v. Johnson said? We can violate the inviolate jury trial right if we have an adequate substitute remedy.
Well, I guess I would, to some extent, I would take issue with the fact that there's a violation simply saying that there's not a lesser of a particular crime, in this case felony murder. I would take issue to some extent with the concept that that is a violation of the defendant's right to a jury trial. Clearly this man did have a jury trial and was able to present a full defense to the charge against him. So to the extent, I guess I struggle a little bit in seeing that as a violation of his right to a jury trial. This man was able to put on defense and had a jury of his peers to determine whether he was guilty of the crime charged. So I would argue, I guess that's where I struggle a little bit, just conceptually, with the premise that this whole argument is based on saying that he was somehow denied his right to a jury trial.
But wasn't that the issue in Miller, that partial jury trial? I mean, there was a jury trial in Miller, but it was part of the issues were not submitted to the jury. And so just the fact that there's a partial jury trial on maybe not all issues doesn't catch that part, does it? You understand what I'm trying to say to you? Miller said that it was okay to have a jury trial where the jury didn't determine the total amount of damages. And right here, they're saying that it was wrong to have the jury decide only part, the principal crime, felony murder, but not decide whether the lessers.
Well, I think again, and it is, as counsel pointed out, I think it's, to some extent, it's a little bit of a circular argument here. I think that the response to that would be that there are no lessers. And there never were. At common law, this was not a crime, and so there have never been any lessers of felony murder. And so I don't think that we've taken away anything that the defendant ever did have at the time of the common law. So I think that would be the most straightforward response to Your Honor's question, is that we don't have to provide anything because we haven't taken anything away that he ever had at the time of the common law. If there are no further questions with respect to either of the issues, we would simply request that the defendant's convictions and sentence be affirmed.
Any more questions? Thank you, counsel.
Thank you.
Just quickly following up on Justice Johnson's question, the two-part test in Miller requires that the court find that the remedy is reasonably necessary in the public interest to promote the public welfare, and in this case, the state has not argued that that's at all necessarily true. They've abandoned that issue. And whether or not the legislature substituted an adequate statutory remedy, and we would argue that, of course, it did not, because it just merely removed those lesser included offenses. And going back just to Justice Byers' question during my portion of the argument, the thing that I keep coming back to, and ultimately the court may agree or disagree with this, but the thing I keep coming back to is that when you're talking about Section 5, this court has said that what the common law was at the time is what is preserved under Section 5. And the common law at the time allowed for lessers of any degree of the crime charged. And I do not think that it is necessary for us to say that because felony murder was not necessarily a common law crime at the time, that therefore that didn't apply to felony murder. It's a crime now, and the right that we're talking about that was preserved at the time was a right that the jury had to consider the lesser degrees of any charged crime. And so our argument would be that the crime charge now was felony murder. There are lessers that could be potentially factually applicable, as we argued in this case, and I would disagree with the state about the adequacy of the briefing on that particular prong of it.
But when you say that, you're applying a statutory test.
That I'm applying the statutory test to.
That it's factually appropriate to have those as lesser included offenses.
And I think that's that's part of our traditional analysis, is that if there's not, I mean, I don't think you have a constitutional right to degrees of the same crime that do not actually apply to the facts of your case. I mean, I think there are limits to that, in the sense that factually speaking, we can look back and say, okay, we're not just going to blanket give things that obviously do not apply at all. We're not going to give intentional second degree on a felony murder argument, because that would not logically make sense based on the facts of the crime. So I don't have a problem with us limiting that, what is available based on our factual analysis. The question is whether or not the legislature has removed the right for the jury in a defendant's case to consider any lessers. And I think there are lessers that are factually appropriate here that could have been considered. Other than that, I didn't have anything else to add.
So really what you're saying is, if the legislature, the constitutional right you're talking about is really, if the legislature creates a crime, it is required to identify lesser included offenses that might be given as instructions when someone is prosecuted for that crime.
That would be our argument, and I think the problem here is that, I mean, this court has said in Miller v. Johnson that there are ways to get around the due process problems that are created by eliminating some of those common law rights, but in this particular case, the state hasn't made any of the arguments that this meets any of those requirements here, because it was just eliminated. It wasn't replaced. There wasn't any allegation of a public interest that was put forth to justify this. I mean, and I think when you go back and you look at the changes that were statutorily made, I mean, it was pretty obvious that it was in response directly to the Berry case, when the legislature changed the felony murder lesser included in this case. So, so we would argue that to the extent that the state may fall back and rely on any of those arguments, that they haven't made them in their brief.
So really the court-made rule for felony murder before Berry was unconstitutional.
It wasn't. It was based on the wording of the different statute than what we're talking about today. I mean, what happened was the statute that was found unconstitutional, or the statutory, it was the case law made rule according to the statutory language. And that statutory language in that particular statute has not actually changed. It's the amendments that they made both to the felony murder statute and then to the lesser included statute. With that, I see we've run out of time. I appreciate the court's time this morning.
Any more questions? Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.